Everyone. This is Tracy again. Now we're going to go over some evidence regarding to back up um, my allegation regarding my house being stolen. So this is an email, as you can see in the on the right side. It's it's 16 pages total, but it's a multiple emails in one. So I'm starting with the initial one on November 18th, sent at 9:23 a.m. And Dr. Green is myself. Um, so on November 18th, 2024, it's addressed to the Supreme Court of South Carolina, Office of Disciplinary Counsel, and Lexington County Courthouse. It's a notice to cease and desist, as well as a motion to reconsider. Before I begin, today's date is November 23rd, 2024. I have not received a response in regards to the request for things to be changed. I have not received a response regarding that yet. We'll get more into that later. Okay, so I write here, this defendant is alerting you to the third erroneous statement discovered in Judge James Spence, November 14th, 2024 foreclosure order. Immediate cease and desist of publicizing the errors is requested. Pages 1 and 3 are discussed in previous emails. See below. Here is page 2. So I am not going to go over everything in the order. This is the original order, as you see on the side. The court's timestamp is November 14th, 11:59 a.m. But what I want to point out is there's several errors actually, but what I want to point out is one in particular. Right here, it is written, the court further notes that since defendant did not appear to argue the below filings or motions, since defendant did not appear to argue these matters, the court deems these motions abandoned. Okay, so, and this is my response here. As requested by the court, this is my response here. As requested by the court for reasons why it should not have rendered verdict in this case, this defendant, myself, notified said judge on November 12th, 24, 10:39 p.m. of the order to show cause and restraining order filed against him. Here is verification. This is an email that was sent Tuesday, November 12th, 2024, 10:29 p.m. Good evening again. Judge Spence, a team response is forthcoming. 2, with regard to, one, a team response is forthcoming. 2, with regard to the requested state and federal law or case that would prohibit your ruling in this case, in addition to the summary judgment rebuttal, associated appendix, defendant's proposed order, and responses to judge's request documents, please consider the following. Section 14-11-130, power to compel attendance of witnesses and to punish for contempt. U.S. Code 28, 455, disqualification of justice, judge, or magistrate judge. Rule 53A1, B2, Masters B. Rule 65, Federal Rule of Civil Procedure. An application would be made by plaintiff of a temporary restraining order and an order directions defendants to show cause why defendants should not be preliminarily enjoined. Thus, legally, plaintiff is unable to be in the presence of defendants pending judicial review. Please pardon the delay. Thank you, Tracy. I'm going to bypass the privacy notice, and I go on saying or writing, however, judgment was rendered anyway. The third noted error in the judgment order is as follows. Since the defendant did not appear to argue these motions, the court deemed these motions abandoned. Material fact. On June 20th, 2024, 1:21 p.m., 1 day prior to the scheduled hearing, the court was notified of the order to show cause and restraining order restricting this defendant's ability to be in said judge's presence. Yet the court continued with the summary judgment hearing in defendant's virtual attendance, despite receipt of the legal notice I could not be in his presence when I called the morning of the hearing. I repeat, this defendant was present but denied access to the motion hearing because of her compliance with the order to show cause and restraining order. Here is verification. This is another email sent. This one sent June 21st, 2024 at 10:20 a.m. I write, Judges Spence and McLeod are included on the email due to persistent filing issues. Dear Clerk of Court, the case number is included at the bottom of the attachment. Respectfully, and there's my name. I also include a list of personnel who received the email also. I'm going to continue on down. This is another email sent June 21st, Friday, June 21st at 10:08 a.m. I write, Judges Spence and McLeod are included on the email due to persistent filing issues. Dear Clerk of Court, please file the attached June 21, 2024 response, 20 pages. And that response only included just an excerpt, but that response have verification of calls made the morning of to the courthouse. One at 8:53 for 3 minutes 6 seconds. And the next one was actually to a number that the courthouse gave me where I spoke to Judge Spence. And that was at 8:57, a 5 minute 3 second call. I write, be it known, this defendant spoke directly to Judge Spence this morning at, and the number I blacked out here. Upon his answering the phone, I am present and requested access to the motion hearing, which has been denied due to contested hearing. Be it known, plaintiff contested this motion hearing due to 6-day filing delay of defendant's motion to move to inactive roster on February 6th, 2024, which allowed plaintiff to file summary judgment the following day. The court has not addressed this persistent issue. To explain, I, as the defendant, filed a motion to move this case to an inactive roster on February 6th. The clerk of court, who's responsible for filing all documents, did not file my submission, the submitted document, until February 12th, excuse me. The clerk of court, I repeat, the clerk of court filed a document I submitted on February 6th, on February 12th. That gave the plaintiff room to file for summary judgment on February 7th. This has been a persistent issue that the court has still not addressed. I continue to write, June 21st, 2024 is not the first time Judge Spence and U.S. Bank National Association met unlawfully without this defendant being present. Neither has the court addressed the 6-day delay of this defendant's motion to move to an inactive roster. Neither has this court addressed the plaintiff's fraudulent notice of home acquisition delivered to the defendant via certified USPS mail August 3rd, 2022. Is this not mail fraud? In summary, Supreme Court of South Carolina, Office of Disciplinary Counsel, Lexington County Courthouse, please assist Judge James Spence in correcting all said errors, refraining from publicizing any and all errors. Again, please cease and desist publicizing any and all errors. If these errors led to an incorrect judgment, this defendant requests correction, with this notice also serving as a motion to reconsider, please. For review, attached are the following. And I attached 5 documents for the Supreme Court of South Carolina, the Office of Disciplinary Counsel, Lexington Courthouse to review. The Lexington Courthouse and the Disciplinary Counsel so already had those documents. Okay, and that is the end of this first email. Thank you.